So, in today's topic, we're going to be talking about rights for landlords and tenants when it comes to things like co-tenants, subtenants, and guests. Let's get right into it. So, what is a co-tenant? A co-tenant is defined as two or more tenants who rent the same property under the same lease or rental agreement. Co-tenants are generally jointly and severally liable for paying the full amount of rent and complying with the full terms of the contract they signed with the landlord. So many tenants would choose to live in shared housing if they can for a variety of reasons, such as marriage, or romantic cohabitation, or simply because they just can't afford the rent on their own. And this is a popular reason in California, as rents tend to be very high compared to some other states. But why would landlords want to sometimes limit shared tenancies when these limitations are statutorily allowed? Well, because changes in occupancy, subleases, and assignments and roommate conflicts can be a major source of confusion for a property owner. Now, when you screen co-tenants, if you are going to allow them, you have to ensure that the same general rules that apply to screening any applicant are applicable to screening co-tenants. Therefore, the property owner should require each applicant 18 years of age or older to complete an application to rent and should evaluate the applicants to determine whether they meet you, the landlord's, established screening criteria. The main point is that you have to treat every applicant the same, no matter if they're applying on their own for a new vacancy or if they're applying as a co-tenant. So if you have certain policies that allow married couples to pool their income, for example, or other perks, you have to afford non married couples same rights. Now, California obviously honors all of the American federal disabilities under the American ADA. They recognize all of the same disabilities, all the protected classes, but they also take it a step further. So, as I'll talk about in a minute, there's certain classes that aren't even recognized as protected under federal law, but are under California. Now, when you are going to allow co-tenants as a landlord, you have to ensure that every person residing in the unit is named in the rental or lease agreement as either a tenant or occupant. And I'll explain the difference in a moment after this. But it's recommended that anyone over the age of 18 be named as tenants and be required to sign the agreement. Now, individuals under the age of 18 should be listed as occupants, not tenants, on the rental or lease agreement of the responsible adult. And minor household members should be added to the rental or lease agreement as tenants who signed the agreement after turning 18. Now, the reason for this is that minors under 18, as well as mentally incapacitated individuals, are not legally allowed to sign a contract. If they do, it's unenforceable. So they should at least be listed as occupants. So you cannot necessarily name them as tenants since they don't have any obligation to you directly to pay you rent or abide by the covenants of the lease, but their sponsor, essentially the tenant, who is either their guardian, their parent, they do carry the responsibility. So by virtue of the tenant, that dependent occupant minor or dependent occupant disabled adult does have an obligation just one step removed through the tenant themselves. Now, property owners should maintain complete and current information on every person who is renting the unit or residing in the unit. And that should be obvious as to why. And if it's not obvious, it's because you need to be able to identify who's there for reasons like an emergency, or if you have to name all of the known occupants in an eviction suit. And you should also name all the unknown occupants, such as John or Jane Does, if you don't know their name. Now, there are many benefits to roommate agreements, and I will talk about some of the benefits and how to make a roommate agreement. So, first, you should not allow roommates to go without some kind of agreement. Now, you can't require them to have one, but you should strongly encourage that they do. Now, this is primarily for the benefit of those roommates, but indirectly for your benefit as a landlord. Because when they are disputing over any of the myriad but common reasons why roommates argue, such as for who is obligated to pay what amount of rent, who was supposed to clean up their area or the common area. These are all things that can spill over into your life if you're the landlord or the property manager. So it's to your benefit, not just to the roommate's benefit, to encourage them to sign a roommate agreement. And what should be in the roommate agreement? Well, at a minimum, a roommate agreement should include provisions that cover rent, utility bills, guests, who can come over, how often, privacy requirements, what are the quiet hours, who owns what, who has access to what food, and if food is going to be shared, how the security deposit will be paid and recovered, who it's going to be issued out to, as well as parties and other things that might be probable. And the more you do this as a landlord, the more things that you'll recognize are common issues and you'll want to add to your roommate agreement template for them to fill out. Just make fields that they can fill out. Now, again, it's not binding on the landlord, but it is binding on the tenants, i.e., the roommates who sign it. And it's not a landlord's responsibility to make this agreement, and definitely not a landlord's responsibility to enforce roommate agreements. And a landlord should not get involved in the enforcement of roommate agreements. But encouraging tenants to make a roommate agreement can be to the landlord's benefit, because roommate disagreements are not good business for the landlord. Now, the landlord should consider keeping a blank template and encouraging co-tenants to make one for themselves if they wish, or just fill out the template that the landlord can provide to them for their optional use. And the roommate agreements can just be found online. They don't have to be formal. There really aren't any statutory requirements for them per se. And I'm not sanctioning any specific forms, but if you go to eforms.com, you can probably find some decent ones. If you want to have your lawyer make one, obviously that's better, but I think if you are watching this, you're trying to save money by not just paying a lawyer to do things that you probably could do wrong. Now, when co-tenant disagreements do become the landlord's responsibility, that would be the exception to the rule that landlords are normally under no duty to involve themselves in disagreements among tenants. And if any dispute among roommates becomes serious enough to threaten the health and safety of tenants or otherwise disrupts the quiet enjoyment of other tenants, then the owner not just can, but probably should step in to minimize potential liability. Now, owners should ensure that their tenants understand that it's not the owner's responsibility to mediate conflicts among roommates, and that the entire household could face eviction if the conduct of any household member or guest violates the lease or causes a nuisance. So, does a landlord have to allow co-tenants? Well, local rent control ordinances and fair housing laws could prohibit a landlord from denying a request to add a new co-tenant or occupant, or imposing financial burdens as a condition of approval. For example, a policy that would prevent tenants from adding their minor child to the rental or lease agreement as an occupant, or which requires a tenant to pay an increased security deposit, could violate fair housing laws. And similarly, a disabled tenant may require a reasonable accommodation to have a live-in caregiver, or a tenant may need a reasonable accommodation to add a disabled family member to their household. So, due to these various practical and legal considerations, rental property owners should develop a clear policy in conjunction with their attorney for handling requests to add a new co-tenant or occupant, and then should apply that policy consistently. So, what happens to the remaining tenants when one co-tenant vacates? Well, when at least one of the original tenants vacates and is replaced by one or more new tenants, it's generally in the best interest of the landlord to have all of the new tenants sign a month-to-month rental agreement. But what if the tenancy is based on a fixed term lease and the occupancy changes partially through the lease term? In that case, one option would be for the landlord to execute a change in occupancy addendum, which clearly specifies which tenants are remaining, or vacating, and requires any incoming tenants to acknowledge receipt of the existing rental or lease agreement and be bound by its terms. So, is a California landlord allowed to do a partial eviction where only one tenant is named in a notice to terminate? In short, the answer is no. If it's necessary to terminate the tenancy of an offending tenant, then all tenants must be named. However, a landlord can legally hold all co-tenants responsible for the negative actions of one tenant and terminate the entire household's tenancy with the appropriate notice. So, what are some of the drawbacks of using separate agreements for co-tenants? Well, the inability of landlords to institute partial evictions has been cited as a reason why some landlords prefer to use separate rental agreements for each tenant. But just one of the possible downsides to this approach, i.e., of using partial evictions and using separate rental agreements if you can't do partial evictions, could outweigh any of the benefits, which is, for example, executing separate rental agreements would basically eliminate each tenant's independent obligation to be fully responsible for the rent of the others. And that is one thing that a landlord can utilize if the rent is not coming in. The landlord doesn't have to hold back and wait for the defaulting co-tenant to pay their rent. That's the obligation of the co-tenants to work it on their own, not for the landlord to get drawn into it. Another reason not to allow separate agreements for individual co-tenants, and it's less important but still notable, is that it's a hassle for the landlord to manage multiple leases or rental agreements for individual tenants. This could require keeping track of multiple expiration dates and ensuring that whenever an update is made to one agreement, the same update is made to all. And if it's not, then a landlord could find themselves in trouble if they, for example, restricted one co-tenant from doing something that the other co-tenants are still allowed to do for no other reason than the landlord just forgot to make that updated covenant in the new rental or lease agreement. So when a tenant wants to have a long-term overnight guest, is what we're going to talk about now. When we're talking about guests, we're talking about overnight guests. And unless the tenancy is a mobile home tenancy, which today's presentation is obviously not going to cover, that's a different presentation I did on the MRL, the mobile home residency law, there is no predefined minimum number of days that a landlord is obligated to allow overnight guests in a tenancy. Now, this is why I strongly urge landlords to clearly specify how many days a guest can reside in a rental unit. So, how many days is a reasonable maximum for overnight guests? Well, if you're looking for help in deciding how many days to limit overnight guests, you could consider that for mobile homes, as I just talked about. California law permits guests for up to 20 days consecutively or up to 30 days in a calendar year without permission from the park owner. And anything beyond that would require an agreement. So if you're a landlord and you're looking for a reasonable number to limit overnight guests, you might want to be influenced by California's mobile residency law. There's no guarantee of how any judge will rule on any decision, but that seems a reasonable belief that 20 days consecutively or 30 days in a calendar year would be a reasonable restriction for overnight guests. And when it comes to residential tenancies, which is what this presentation is on, not mobile homes, a landlord is mostly free to restrict guests in terms of number of days, so long as the landlord doesn't restrict the type of guests. And while it should be obvious, but in case it's not, a landlord can never restrict guests based on a category that is protected under state law, which I mentioned earlier, of course, in California offers broader protections in favor of the tenant than federal law generally does. Now, California, for example, even allows protections for unmarried couples. And if a guest ever claims that he or she is a tenant organizer or is there to provide tenants with information about their rights under California law, then a landlord absolutely must not restrict these types of guests. This would be similar to union organizers under business contexts. Both have rights and protections to be there, and a landlord could face serious penalties for interfering with their right to help others understand their rights. Now, one of the only exceptions would be where the tenant organizer is inciting a disturbance or otherwise interfering with the other guest's right to quiet enjoyment on the property. And where that is the case, the landlord could and likely should correct the disturbing behavior. So remember that the rules are not written, and if rules are not written, then they're generally not enforceable when it comes to landlord-tenant law. Again, if the rules are not written, they're generally not enforceable. So this is one of the reasons why standards for guests should be unequivocally spelled out in the lease or rental agreement. Now, in addition to having clear rules in place, the landlord should also have systems in place to monitor and track the length of stay by overnight guests in the landlord's properties. And if the landlord doesn't enforce these rules and limits, then the guests could eventually begin to adopt rights that will make removal more difficult and may necessitate the removal of the main tenants as well. So when a tenant wants to have a long-term guest, I recommend using a long-term guest addendum. And the reason for this is it makes it quite clear, quite unequivocal, that this is a guest. They're not a tenant. They will not adopt tenant rights. And it is signed by the guest, by the tenant, should be signed by the landlord, and it also shows whether or not the guest will have access to things like the common areas, just the gym, for example. So you're minimizing extra crowding by someone who really doesn't have the right to be there. They're just there by privilege, and minimizing wear and tear on the facilities. So how to handle overstays if that guest who agreed to be there for up to 20 days but no longer decides, I love it here and I'm just going to stay a little bit longer. Well, when a landlord becomes aware that an overnight guest is about to or has already stayed longer than the contractual maximum number of days under the lease or rental agreement, that landlord should treat the overstaying guest, especially one who didn't get permission, who just showed up and was unauthorized, essentially as an applicant to rent, and provide the overstaying guest with an application to rent. Now, a landlord should make sure to provide all of the written disclosures that are normally required whenever a credit check is run on an applicant. And if adverse information is found that would deny the tenancy, then a landlord would need to include additional forms, such as a notice of denial of rent. So if the overstaying guest, now turned rental applicant, does not meet the same objective standards that any other applicant would be expected to meet, then the landlord's next option might be to serve the original tenant with a 3-day notice to perform conditions and or covenants for violation of the contractually agreed upon maximum number of days for guests. Again, that would be a 3-day notice to perform conditions and or covenants or quit, which means if they don't get rid of their guests within the 3-day waiting period, then they have essentially forfeited the tenancy, and it entitles the landlord to commence an eviction, which is known as an unlawful detainer in California. So is the landlord obligated to offer tenancy to a guest? So it shouldn't be the obligation of the landlord to be forced to offer this extended guest a new tenancy. So is every landlord obligated to do this? Well, what are some of the reasons why a landlord might not want to turn an overstaying guest into an additional tenant on the lease? Well, one common reason is that additional occupants in a unit will probably increase wear and tear and the consumption of water, electricity, gas, which really should only be of issue if these are not sub-metered and the landlord's paying for them because they're herself. But another reason might be that some landlords won't or can't increase the rent to compensate for the additional wear and tear and consumption of utilities when additional guests are moved in. So the landlord would essentially be having to bear increased expenses without increased revenue to compensate for these increased expenses. So when is a landlord obligated to accept an overstaying guest as an additional tenant, and when can a landlord refuse? Well, this depends on what type of guest. If the overstaying guest is an immediate family member or caretaker, the landlord probably does need to offer them a tenancy. But any other type of guest is probably not entitled to the offer of a tenancy. But before a landlord makes that determination, or if you are a tenant who thinks the landlord made an improper denial, it might be wise to consult with an attorney with competence in this area of law to ensure that a local ordinance doesn't change this presumption. Now, what about guest fees? Well, because of the added wear and tear and consumption of additional utilities that will probably be caused by additional occupants, it seems reasonable that a landlord should be entitled to offset the landlord's costs by charging a guest fee if they're not going to bring that uninvited, particularly unwanted guest into the tenancy by offering them an application to rent. If they're just going to allow them to stay as a long-term guest, or every time the tenant brings over a guest, charge them a fee. Well, here's some of the potential problems to consider before a landlord charges these fees. So first, a landlord who charges guest fees, especially for guests that stay beyond the contractual maximum, might be considered to have waived the right to enforce the contractual maximum because they're accepting guest fees and thus accepting the guest beyond the 20 or 30-day cap on guest overstays that might be in the landlord's lease. Now, this could potentially even change the guest status from guest to tenant, and this could make an eviction more difficult. And the landlord would now be on notice that there are additional occupants in the premises and would need to identify them as John Does or by name specifically. Next, by charging a guest fee, the landlord might be found to be part of, well, the guest fee might be found to be part of the rolling 12-month gross rental rate that the landlord has been charging monthly for the tenancy. And the significance of this is that for property subject to AB 1482, which took effect in 2020, there are now restrictions on how much and how often the landlord can increase the rent over a rolling 12-month period. Now, typically this rent cap is 5% plus the change in CPI, never to exceed 10%, but some local ordinances restrict this amount further. So if you're going to charge guest fees, and I'm not necessarily suggesting that you should or can, make sure the amount you charge can be reasonably substantiated based on actual costs for increased utility consumption and depreciation, and not due to your own arbitrary and subjective estimations. Now, at the time of this presentation, which is July 2023, just about, neither statutory nor common law is clear on when and how much a landlord can charge for a guest fee. But one strategy I've seen landlords use is to calculate the change in average baseline usage from months prior to the guest presence to baseline usage after. I'm not saying a judge would necessarily allow that, but it has been done, and it's up to you whether you want to do that. I'm not going to give my stamp of approval. Differences between occupants and guests. So it should be relatively clear what constitutes a tenant, because a tenant will normally be a signatory to a lease. But what gets more muddled is who is an occupant and who's a guest. So if a non-tenant occupant is only temporarily occupying the unit, then he or she is a guest, and it would not be appropriate to name guests in a rental or lease agreement that the tenants are on. However, occupants are typically named in the rental lease agreement, but they do not need to sign that rental or lease agreement. Whereas, as I've mentioned before, a tenant would be specifically named in and be a signatory to the lease. Now, one common category of occupants would be minor children living with a tenant. Occupants under age 18 do not normally need to be named in the lease agreement. Now, another category, as I mentioned before, of occupants is when you have a person over the age of 18 who's permanently occupying the unit to care for the tenant. And similarly, you could have a lawful occupant but not a tenant, where a disabled adult lives with the tenant who is caring for the disabled occupant. Now, landlords must be very careful when denying disabled individuals or their caretakers, as such requests are likely considered reasonable accommodation requests, and a landlord can find oneself in expensive legal trouble if a denial is given without going through an interactive process with the individual requesting the reasonable accommodation. For example, when a disabled adult lives with the tenant, he or she may be designated as an occupant as a reasonable accommodation. Now, what is a subtenant? What's a sublease? We're going to get a new category, and we're wrapping up, almost done. A sublease or subtenancy is an agreement in which a tenant rents all or part of the leased premises to a subtenant. Now, the master tenant normally does not relinquish control over and plans to retake possession of the unit at a later date. Now, in a normal tenancy, the original tenant, also known as a master tenant in a sublease, has a landlord-tenant relationship with the property owner. But in a subtenancy, the master tenant now becomes the landlord to the subtenant. So in the absence of a prohibition against subleasing and assignment in the rental or lease agreement, subletting or assigning the right of possession by a tenant is generally allowed in California. Now, while subtenants could be roommates, subtenants are not co-tenants. Now, why is this? Well, because a co-tenancy exists when two or more tenants rent the same property under the same contract with the landlord. However, a subtenancy generally exists after the original contract was signed because the master tenant and the landlord are signing at different times. And because the subtenancy is signed later, the master tenant and the subtenant are not co-tenants. So again, the co-tenancy means that both tenants have signed a contract with the landlord. It's generally at the same time, but it could be different if the other co-tenant is added later. But the point is, both co-tenants are in what's called legal privity with that landlord. They both have direct contracts with the landlord. But a subtenant does not have a contract with the landlord. Subtenant has a contract with the tenant. Now, it's generally not in an owner's interest to allow subleasing. And why is that? Well, because it takes control away from the landlord, owner, property owner, however we're referring to the person who has ultimate control over the property and is in charge of screening applicants. So it takes away control because the landlord or owner or property owner, whoever we're talking about here, is going to lose the ability to properly screen the applicants for who's going to reside in the rental unit. It also limits who the owner can hold liable for the rent and damages. So subtenants basically have no contractual relationship to the owner because subtenants have not signed a contract with the landlord. Now, this means that the owner can only go after the master tenant, not the subtenants, for unpaid rent. However, both landlords and tenants should recognize that some local rent control and or just cause eviction ordinances will limit an owner's ability to prohibit subleasing in certain situations. Now, what's an alternative to subleasing that still balances the benefits of the tenants as well as the landlord? Well, one example could be having a policy of allowing co-tenants but not subleasing, which would give the owner the ability to screen all potential tenants and hold all tenants liable for the rent while still allowing prospective tenants to combine their resources to rent an apartment or house. All right, and wrapping up, assignments. Now, an assignment is an agreement in which the original tenant agrees to transfer all of his or her legal interest in a lease to another person. So the old tenant would be the assignor, and the new tenant would be the assignee. Now, the assignee to whom the lease is transferred basically steps into the shoes, to use a legal jargon, of the original tenant, the assignor, and becomes the new tenant of the premises with a direct landlord-tenant relationship with the owner. Now, landlords should think carefully before allowing assignments in their leases or rental agreements, and this is because by not prohibiting them, they might be granting an implied waiver. So similar to allowing subleasing, assignments can take away some or all of the landlord's capability to screen assignees and ensure that any assignees otherwise satisfy the landlord's uniform criteria for all tenants. So what are some of the differences between assignments and subleases? Well, in a sublease, the master tenant has not transferred their rights fully or permanently to the subtenant because the master tenant intends to return, either to reoccupy the premises or to sublet to a new subtenant at the end of the subtenancy. But in contrast, during a sublease, the assignor does not intend to reoccupy the premises and transfers the assignor's rights completely and permanently to the assignee. So, what are some issues that could arise with rental payments with co-tenants or assignments or subleases? Well, co-tenants may decide among themselves what portion of the rent each person will contribute. And regardless of any such agreement between the co-tenants, the rental or lease agreement usually makes each individual who signs the rental or lease agreement liable not only for his or her share, but for the entire rent, should any other co-tenants default. This is known as joint and several liability, meaning that the landlord can go after either tenant or both tenants if the full rent is not paid on time or the lease is otherwise breached, provided the lease or rental agreement clearly spells this out. So if one tenant cannot pay his or her share of the rent in a particular month or simply moves out, then the other tenants must still pay the full rent. Now, the paying tenants may recover from the defaulting tenant in an independent civil lawsuit, but this doesn't have to be the landlord's problem. Now, landlords may insist in the rental or lease agreement that rent be paid with one rent check for the entire rent amount rather than several checks from individual co-tenants, but the landlord really can just let the co-tenants work it out among themselves. So another issue might be with security deposits when you have co-tenants. And the purpose of a security deposit is to ensure that the unit is restored to its pre-move-in condition, of course, exclusive of wear or tear. Now, it would therefore defeat that purpose if the security deposit or any portion of it were returned by the owner to an individual tenant before the unit is returned to the owner and returned in decent enough condition to not justify the deduction of a security deposit. Now, California law does not require an owner to return the deposit until 21 days after the unit is returned to the owner's possession, and does not provide for the return of a deposit to an individual roommate. Now, unless the rental agreement provides otherwise, the security deposit is not divisible and stays with the unit until the last of those co-tenants has vacated. But accordingly, the deposit should not be returned until after the unit has been vacated and the owner has had the opportunity to assess and make appropriate deductions for damage to the premises. Because the security deposit disposition is not done until the unit is completely vacated, the owner does not have the right to inspect the unit when a co-tenant vacates, but the unit remains occupied by other co-tenants. So unless the tenants have agreed otherwise in writing, for example, if a replacement roommate bought out a former roommate's portion of the security deposit, the owner should issue the security deposit refund payable to all the tenants, even if one or more of the tenants vacated at an earlier time. So as a practical matter, this means co-tenants must work out among themselves what to do when one tenant leaves. And if unrelated co-tenants are entering into a lease or rental agreement together, then the landlord may want to make this clear at the outset of the tenancy so it does not come as a surprise when one tenant plans to vacate. So, some potential strategies for co-tenants to recover security deposits. And the following solutions are commonly used between co-tenants to resolve the type of situation where one tenant leaves and the others remain. 1. An incoming replacement tenant may pay the departing tenant his or her share of the deposit. Now, this is advisable only if the unit has been maintained prior to the new tenant taking possession, since any preceding damage would be imputed to the new tenant and other remaining tenants. 2. If there will be no replacement tenant, the remaining tenants can essentially buy out the departing tenant's interest in the security deposit. 3. The departing tenant may want to wait until his or her co-tenants have vacated and then seek reimbursement at that time. But this might create problems in the situation where damage occurred to the unit after the first tenant vacated. And 4, if the tenants cannot agree to resolve the dispute among themselves, then the tenant seeking to recover his or her share of the deposit might bring an action in small claims court against the co-tenants to recover their share of the deposit. All right, so unauthorized occupants. Well, what are they? One example of unauthorized occupants is where a person moves into a rental unit without the landlord or master tenant's authorization. Now, this might happen, 1, where the current tenant allows another person to move into the rental unit without the owner's knowledge and consent, or 2, where the current tenant has abandoned the unit and improperly allowed another person to continue occupying the unit, also without the landlord's knowledge or consent. So what can the landlord do when there are unauthorized occupants? Well, if a landlord discovers that a tenant has improperly moved in an occupant with the landlord's knowledge, without the landlord's knowledge or consent, in other words, an unauthorized occupant, the landlord should first determine whether the tenant who improperly allowed the unauthorized occupant to move in is now in breach of the lease or rental agreement. Now, while this may arguably be an incurable violation that might warrant a 3-day notice to quit, I would recommend first attempting to work with the offending tenant to remove the unauthorized occupant. In other words, the landlord should consider this a curable breach that hopefully could be cured by having the tenant remove the unauthorized occupant, and agree not to move in any future occupants without the landlord's knowledge and express consent. And in order to do this, you would serve the offending tenant a 3-day notice to cure or quit. If the tenant is not willing to comply or does not comply within the 3-day waiting period, then the landlord can commence an unlawful detainer action against the offending tenant. And if the landlord prevails at trial, in which the question of lawful possession is being adjudicated, then both the offending tenant and the unauthorized occupant could be removed from the premises forcibly, if necessary, by the sheriff. Now, always remember that landlords and tenants should check local ordinances before acting, as these ordinances might restrict landlords' capabilities and boost tenants' rights. All right, well, that's it. Did you find this helpful? And what topics would be helpful for me to cover next? My name is Nick Cohenmeyer. I know your time is valuable, and I appreciate you sharing it with me. I hope you found this helpful.